Okay, let's break this down right now. Joining me once again is trial attorney John Phillips, and I'm also joined here by former prosecutor Michelle Heyman-Kantor. Michelle, I want to start with you, and thanks for joining us. The defense seems to be very keen, and you correct me if I'm wrong, on saying, well, if the prosecution, and it's their burden, they haven't established every circumstance of what happened to Taylor Wright, then that, ladies and gentlemen, is reasonable doubt. If we don't know when she was killed or exactly how she was killed, that's reasonable doubt. Is he accurate?
So good morning. He's accurate in saying it is the prosecution's burden that they must prove the case beyond a reasonable doubt. That's absolutely true. And he did start off that way by explaining to the jury her constitutional rights, that she's presumed innocent until proven guilty, and that the reasonable doubt comes from the prosecution side. But reasonable doubt is a standard that the judge is going to give the law to, and the jury is going to have to decide for themselves based upon all the facts and the evidence that they're given. So they're going to stack up all of the facts that the prosecution has given to them. The cell site records, the Home Depot supplies, the statements that she made. You know, keep in mind that when the police say anything you can and will say be used against you, they mean it. She gave those 3 statements. That certainly doesn't look good. So they're going to weigh all of that. And the defense, as he's trying to do now, is to show the reasonable doubt by showing the cocaine statements, or that there's no forensic evidence or DNA evidence, which may be his strongest leg to stand on. So that's what he's doing right now.
Yeah, and John, he's very big on saying the state can't just assume or have conjecture here. They need to prove their case. So one of the things that he said was, and I thought this was interesting, was like, how would she have had access to Taylor Wright's phone? There's only 2 people who would have had access, Taylor and Cassandra, her girlfriend at the time, and then she took her thumb and used it? I mean, he's trying to cast this doubt here. Does this kind of conversation persuade you?
It doesn't, but you got to do what you can do. In you know, the time of death, and I'm looking at my notes, the cell phone, and we all know that the cell phones also sometimes have an override if you know the code. The time zones, the impeachment. Look, you got to build a defense somehow, and so take all of the things you can put in your bucket and make an issue out of them is fine, but you don't have to prove, state doesn't have to prove every single fact beyond and to the exclusion of any reasonable doubt. They got to prove their case, and so you know he's making points that are arguable, and I imagine the prosecutor's gonna pound them on them, but you take what you can get, I guess.
Yeah, no, and I'm glad you mentioned that. The prosecution will most likely put on a rebuttal argument to counter everything the defense is saying. Okay, so before the rebuttal starts, let's get some perspective. Michelle, what do you think? How did he do? I mean, this has been a very interesting case so far, and now we just heard the defense.
So I think he did what he could. First, let me start with what I think he did well. I think he hammered home that there was no DNA evidence, and juries have been watching CSI and Law and Order for as long as we can remember, and that matters to them. So that could be something that they can pin some reasonable doubt on. I liked what he did with the concrete. I think that was something that had stuck with me for a long time, that there was video evidence of the defendant buying the same concrete and potting soil that Taylor had been buried with. And he had said during his summation, it's not a concrete case because the supplies she had brought were not the same. I thought that was a pretty good rebuttal to what the prosecution had said. As for the back injury stuff, I'm not really buying it. When you have your mom testify, you're really scraping at the bottom of the barrel. I mean, she's the definition of an interested witness who cares more about the defendant's welfare than the mother. So I'm not really buying the physical evidence as much. And the prosecution had said on their closing that her body language had changed in her 3rd statement. So they're going a little bit of tit for tat with that. But one thing I didn't hear him say, which really stuck out for me, was he didn't cover the cell site evidence too much. And that's pretty strong for the prosecution. So I'd be interested to see how that plays out.
Well, I'm sure the prosecution is going to mention that one more time in the rebuttal. Okay, short, sweet rebuttal closing. John, I'll start with you. How did she do?
She did great. So part 1, methodical, PowerPoint, digital footprint, go through the evidence and tell the story. Defense did a very imperfect closing of a very, very imperfect crime, kind of throwing some stuff against the wall, and then on rebuttal, none of it stuck, in my opinion. I mean, you made a couple of good points, but you kind of threw some stuff together that she just smashed back down. It was literally, and I got chills during the first part of that, one of the best overall closings I've seen. But she had, not just circumstantial evidence, but digital, on her side, on the state side.
Yeah, that digital footprint, as you mentioned, is really, is really hard to ignore. And as you said, as Michelle said, you said he didn't really focus so much on that cellular data, which is quite incriminating. So I also thought it was kind of powerful, Michelle. I'm curious your perspective on having the same prosecutor delivering the closing and the rebuttal there, never losing a stride.
Absolutely. And she was super methodical and clinical on the first summation. And during the rebuttal, I was really happy to see that she found her voice. She got a little bit angry. And I think she needed that passion to be infused a bit. But I mean, she hit everything she needed to. She rebut the point that I think is very strong for the defense about not having DNA. And she said the judge is going to let them know that her job is to prove the case beyond a reasonable doubt, but the law doesn't say how it needs to be proved. So she can prove it however she needs to, and she doesn't have to use DNA. And I was really happy to see her hammer that home, because I think that's a point that the defense did well. And she can do it any way she wants. So that's a huge thing, because juries I've seen many times really want that scientific evidence, and they need to be told several times they don't need it to find a person guilty. So I think she did really well. I think she did really well also with hammering home. The defendant is CSI. She's trained in this kind of stuff. So if cadaver dogs couldn't even find it, it was going to take the police a little bit of time. So I thought she did that really well, in addition to showing that the ME confirmed that the body was found dead consistent with a September 8th timeline. So I think she hammered home the rebuttal points pretty well.
Yeah, and John, one of the points that the defense brought up, and I'm curious why they said this, although I can presume why, the very last sentence of the defense was saying, you're going to get a verdict form, it's going to say all these things, it's going to say first degree, second degree manslaughter, use your, we ask you, there's reasonable doubt here, find not guilty. Was that kind of a suggestion, hey, jury, even if you don't think that the state, even if you think that she did it, come on, do you really think it's first degree? Maybe it's something less. Is that kind of a sign to the jury that's what you should be thinking about too?
Kind of that George Zimmerman, like, look, there are other things that you could consider here other than first degree murder. We don't think it's, she didn't do it, but it's certainly not premeditated. Look at this other stuff. But I mean, I think they're all in on, I think it's all or nothing here, just on the way both cases were presented. Either they're gonna somehow find some reasonable doubt, or it's first degree murder.
Yeah, it's not a question of a fight gone wrong or something like that, where you might see a lesser charge. Michelle, let's just talk practically what happens here. So after these jury instructions, the jury's going to gather and they're going to start deliberating. But do you expect a verdict today? What's going to happen in that room? Because let's not forget, the judge did ask to streamline this case and get it to the jury by today. We know a hurricane is coming. We know it's Labor Day weekend. How are the deliberations going to be affected by these things?
So they're going to go right to it. I imagine the judge will order in lunch for them, and they're going to start deliberating immediately. And this is finally the time when the jury can start to form opinions. And I think it could happen pretty quickly, especially given that the judge has been harping on this timeline about getting it done by Friday, and we're here. But they're going to be thoughtful and methodical, I would imagine. I mean, that's their job. That's the oath they took. And this is someone's life and liberty at stake. So I would hope they're going to take it seriously and go piece by piece. But the evidence is pretty strong in favor of the prosecution, so they might come back pretty quickly.
Well, we are going to wait and see, and we are going to cover it here on Law and Crime. Now's a good opportunity to take a break. When we come back, we'll break down everything we've seen so far. Stay tuned.